Good morning, Mr. Caparella.
Good morning, Your Honor. Donald Caparella, National Bar. I represent Ms. Fuchsuk, the wife of the settler, Mr. Bone. Ms. Cindy Franklin is also an appellant in this case, representing two different parties. We've decided to split our time as follows. I will use the first 6 minutes. Ms. Franklin will use the second 6 minutes, and then we'll reserve 3 minutes for rebuttal, which I will do.
All right, we'll set the clock for 6 for you. Thank you, sir.
Thank you, Your Honor. This case involves a trust that was executed by Mr. Bone in 2017, and the trust left some portion of his assets to his 4 living children. It also, though, said that the benefits, the property would go to his children per stirpes, which meant that their children would accept it. Then in August, Alicia Mayberry, one of his children, died before he did. And Mr. Bone's attorney, Mr. Thomason, executed an amendment to the trust in August of 2019, a couple months before Mr. Bone died, that changed the trust to cut off the per stirpes, to cut off the grandchildren, in this case the Mayberries. Question for this court is whether that trust amendment was valid. And it is not, Your Honor, because of the following reasons. The Uniform Trust Code 3515-602E establishes that the power to amend or revoke a trust may not be exercised by an agent acting under a power of attorney unless the trust contains express language granting that power to the agent.
Unless the trust or the power of attorney.
Well,
What did you just read?
Well, this says that the trust must give, establishes that the power to amend or revoke a trust may not be exercised by an agent acting under a power of attorney unless the trust contains express language granting that power to the power of attorney.
The trust, yes.
So you first start with a trust in this case. And what's interesting about this is that in my opponent's brief on page 19 said the following: because Mr. Bone was competent, the trust amendment did not expressly authorize Mr. Thomason, the power of attorney, to execute the amendment as the power of attorney in this case. So they've admitted that under the language of this trust, which in no way talks about whether a power of attorney has the right to do something if Mr. Bone is competent, there is no express grant. Now, they argue in their brief that the trust doesn't prohibit a power of attorney, in this case Mr. Thomason, from doing it, but the law says there must be an express grant in the trust that the power of attorney can amend it. So, Your Honor, I respectfully submit that under our argument and under their admission on page 19 of their brief, that they admit that the trust doesn't give the power of attorney expressly the right to do this. That answers that question. So then we go to the second argument. There is a power of attorney that was entered into about 8 years before the trust that gives the power of attorney, Mr. Thomason, the ability to amend a trust or any trust. But again, we go back to Uniform Trust Code, which expressly says that that type of express grant must expressly reference the document. And there was no trust, this trust was not in existence for 8 years later. And, well, you say, well, you could come up with the idea that, well, you want to have that power of attorney just to cover you for all future events, and we're fine. But if you read the comments of the trust code, it says we want the trust to be the governing principle for estate planning for moving property after the fact, and not a power of attorney. We want the power of attorney to allow the power of attorney to do certain things that may not, that may fulfill the intent of the trustor, but are not directly involved in changing the trust dramatically. Under their interpretation, as long as you do a power of attorney before you have a trust, 8 years before the trust, and then you do a trust later, the power of attorney can just do whatever they want. They can get rid of the trust, they can amend the trust, they can revoke the trust, they can do anything they want. And the comments to the Uniform Trust Code says that's not how we want a power of attorney to be used. So we would say that the Uniform Trust Code says that the power of attorney that gives the power of attorney language that gives the attorney, in fact, the ability to amend a trust must reference the specific trust that they have the power to amend. And that did not happen in this case.
And you claim that based upon the Uniform Trust Code comments. Is that right?
On the power of attorney issue.
Yes.
Yes.
Okay.
On the first issue about whether what does the trust mean,
Right.
there is no, and they admit that there is no express grant if Mr. Bone is competent, and there's no dispute he was competent in this case, to let a power of attorney do this. Now they argue this thing. Remember, the settler here had an amendment. Arguably, he died, so it was done totally by Mr. Thomason. They argue that 2 years later, when Mr. Thomason did this, that said, well, the settler, now this is what he wants. And clearly that's what his intent was. But the Childs versus Childs case that I cited from South Carolina makes it very clear that even a settler cannot come back 2 years later and tell you what he intended in his previous trust. He cannot change the language of the trust by saying, well, that's what I really intended, this is how I'm interpreting it now. So if a settler under the Childs versus Childs case can't have, afterthoughts, changes of ideas and stuff for any reason, then certainly a power of attorney can't do it under the Childs versus Childs case. So we submit that the trust amendment in this case is invalid under the Uniform Trust Code and under the language of the trust and the power of attorney in this case. And therefore, you should reverse the trial court and find that the amendment to the trust is invalid.
Thank you, Mr. Caparella. Good morning.
May it please the court. My name is Sydney Franklin. I'm the attorney for Chancey and Craig Mayberry, who are the grandchildren who were effectively cut out of this, being beneficiaries of this trust due to an amendment that was executed by the decedent's then power of attorney. It's our position that the trial court erred in its determination of concluding that this amendment was valid, and that's for two reasons that Mr. Caparella briefly touched on. I want to explore a little bit deeper. The first is the language of the trust itself, which is the later executed document, reserved the settler's power to amend. There is and I'm going to quote directly from that, Your Honor. In the language of the trust, there's one paragraph in the introduction prior to subdividing out into the various chapters of the trust or paragraphs of the trust, which states, I reserve the power by signed instruments other than a will or codicil delivered to the trustee during my life to revoke this agreement and any trust hereunder in any whole or in part, and to amend this agreement in any trust hereunder from time to time in any respect, period. That sentence doesn't give any type of direction of what happens in the event that I am incompetent, which is the next sentence, which even in that situation, if the decedent had been incompetent as settler of the trust, a power of attorney pursuant to the language of the trust itself could only act to amend this trust if the appointment of that power of attorney was specific to this agreement. So it's our position, not only is there not an express authorization for a power of attorney to amend this trust, the language of it, the trust itself, reserves that power to the settler of this trust, who is Mr. Bone. The later executed, the prior executed power of attorney was not sufficient to grant Mr. Thomason the power to amend this trust. When this trust was enacted in 2017, 8 years later, the settler of this trust, Mr. Bone, reserved that power. He took that power back, essentially. In the initial grant from 2009, where he did grant, there is language in that power of attorney that states that the attorney, in fact, can exercise any powers of revocation, amendment, or appointment which I may have over the income or principal of any trust. The later executed document limited that power. It not only limited that power during his incompetency, it limited that power during his competency whenever the language of the trust stated, I reserve this power. That was a reservation of the power to amend by the settler. And unfortunately, Tennessee Code Annotated Section 35-15-602 has only been cited by this court on 3 occasions, none of which actually deal with the subsection E, which deals with amending a trust by a power of attorney. They instead deal with issues such as whether holographic notations on a trust were effective to amend a trust document, and that was in Elizabeth Beck, Hosington Living Trust in 2017. There was a case in Ray, the estate of Hunter from 2019, in which this court determined whether a trust could be amended or revoked by a codicil to a decedent's will. Again, those aren't relevant to defining subsection E and interpreting subsection E. I will note that the appellees rely on subsection C in their brief for the argument that the amendment was in substantial compliance with the terms of the trust and or the power. Your Honor, if you read subsection C, it clearly states that the settlor may revoke or amend a revocable trust, subsection 1 after that, by substantial compliance. That language is clearly directed only at the settlor's amending of a trust. Following that, subsection E of that statutory provision does state that a settlor's powers with respect to revocation, amendment, or distribution of the trust may be exercised by an agent under a power of attorney only to the extent expressly authorized by the terms of the trust or the power. And again, it's our position that the later executed instrument, the trust, which was drafted by Mr. Thomason, who was the attorney in fact, power of attorney was drafted by Mr. Thomason as the decedent's attorney. He testified to such in his deposition, which is part of this record. It seemed that he would be aware of that pre-existing 2009 document in which that power, which granted that broad power and then limited it in 2017 by including that language of reserving the power to amend. There's also a case that the appellees rely on, which is Tennessee Farmers Life Reassurance Company versus Linda Rose. And they argue that this court previously determined, or the Tennessee Supreme Court previously determined, that a large grant of power to change and transact all insurance business on my behalf was upheld in that case after a power of attorney changed the beneficiaries on a life insurance policy. It's a very different situation here because not only do we have language within the trust that directs how and when the trust can be amended and by who and the methods for amending, that life insurance policy, as far as I can tell, didn't have that language, even though in both situations there seemed to be some grant of power within the actual power of attorney instrument. So, Your Honors, we request that you reverse the trial court and find this amendment invalid.
All right, thank you, Ms. Franklin.
Thank you.
We'll now hear from the appellees, and I understand, are you sharing time as well?
I am not, Your Honor.
Okay.
I will be arguing on behalf of all the appellees that
Very
have
good.
briefed the issue.
Thank you.
May it please the court, my name is Dan Barham. I am a partner in the law firm of Barham and Messeri, member of the Williamson County Bar. I represent the appellees in this matter, in particular the estate and the trust of the decedent Bob Bone, the former trustee and executor Andrew Dodson Jr., as well as Sam Bone, the brother of the decedent and now the executor and trustee. The issue is relatively straightforward. Did the amendment that Bob Bone caused his attorney-in-fact to execute on his behalf amend his trust? I am glad that Ms. Franklin corrected her co-counsel on the language of TCA 35-15-602E. That language states that a settlor's powers with respect to revocation, amendment, or distribution of a trust property may be exercised by an agent under a power of attorney only to the extent expressly authorized by the terms of the trust or the power. It's a standalone statute. It sets aside a way for a settlor to cause his trust to be amended, and that is by an existing power of attorney, or presumably one that might come into effect later. But in this case, the power of attorney was existing at the time that the trust was drafted, and under the rule in McFarland, the settlor of a trust is assumed to understand the legal effect of all the language in the trust and the legal effect of all other estate planning documents that might be out there in existence. I did have the thought this morning as to why we're here today. We're here because Bob Bone intended to amend his trust. He stated in this amendment that because of the death of my daughter Alicia, I wish to amend this trust to make sure that any distributions to my children be made only to those children living at my death. And I want to amend the trust in all respects that might express some contrary intent. That's undisputed that is exactly what the amendment says. It's undisputed that Bob Bone asked his attorney, in fact, Bob Thomason, his longtime friend, to draft this amendment. Then he directed him specifically to sign the amendment. Bob Thomason brought the signed amendment to Bob Bone at his home. They discussed it. He presented it to him. He delivered it to the trustee.
But what are we to do with the language in the trust document itself that seems to reserve to the settlor alone the ability to amend? I mean, your brief seems to suggest, well, it doesn't prohibit, but the trust document seems to really latch on to I as the settlor as the only one that can amend this document.
2 points. It's a good question, and it's come up a lot. The language of the trust is a little bit curious. Why would someone state, I reserve the power by signed instruments delivered to the trustee during my life? Why would he say that? I would suggest that this is language not of exclusivity, but language of revocability. Before 2004, trusts in Tennessee were deemed to be irrevocable unless they were explicitly made revocable. I believe that language, reserving the power to amend, is not intended to be a language of exclusivity, meaning that it's only the settlor who can sign a document and deliver it to the trustee to amend. I think it's meant to emphasize that this is a revocable trust. Moreover, it does not exclude other manners of the settlor to amend the trust. I would submit that this amendment that he told his power of attorney to draft and he told his power of attorney to sign on his behalf was a manner taken by the settlor himself to cause the trust to be amended. The record has a lot of different facts that are uncontroverted, that are largely in the deposition of Mr. Thomason, that indicate that there was a lot going on between the parties at that time, and they're still arguing. It seems a very reasonable course of action for a settlor who wants to amend his trust when he is surrounded by a storm of people arguing over what he should do with his money, to have his lifelong friend who has no interest in this money take care of it for him under the power of attorney that he knew existed at the time. There is some argument in the appellant's briefs about whether or not the power of attorney granted a generic power, the terms any and all. And we do argue that the Rose case that the Supreme Court decided is directly on point. Now, that case did deal with a power of attorney and a broad grant to deal with insurance policies. But there the court said, a power of attorney is neither unambiguous or uncertain simply because it grants the authority to transact all insurance business and take any other action. The court went on to say, there's no escaping the significance of the word all and the words take any other action in delineating the scope of the insurance business that the agent could conduct. That to construe it otherwise would be to render the power of attorney in that case to grant the authority to only transact nearly all the business rather than all the business. Appellants seem to want to do the same thing with the power of attorney in this case. They say that expressly carries with it some sort of requirement that the trust at issue must specifically refer to this trust. But that's not what expressly means at all. The word expressly, actually defined in Black's Law Dictionary as clearly and unmistakably communicated, stated with directness and clarity. Well, that's exactly what Rose was getting at, that the words any and all are very clear. They have very plain meaning. And to construe them otherwise would not only defeat the intent of the settlor when he signed his power of attorney, but it would also defeat the intent of the settlor when he went about to amend his trust. Now, this court's also dealt with amendments of trusts before, and the substantial compliance required under subsection C in the of statutory section 3515-602. And I'm happy to answer questions about that. However, where a trust...
What do you say about the Uniform Trust Code comments that Mr. Caparella was talking about that suggests that a pre-existing power of attorney is ineffective to amend a subsequent trust?
He may have suggested that, but the comments don't say that. The comments do say that there are certain formalities that are inserted in the Uniform Trust Code that deal with amendment, but that those formalities are inserted primarily for the protection of the trustee and not the settlor. See, the comments consider a circumstance where you have a different settlor and a different trustee, and the trustee going along in good faith trying to administer the trust may not know that the settlor has executed an amendment, filed it away in his file, and then the settlor passes away and the beneficiaries sue the trustee for some malfeasance when the trustee didn't even know. So there's some formalities in the code that are intended
I think that's very distinguishable from the facts here.
I agree. They're very distinguishable because the settlor and the trustee were the same person. In this case, we need to look further into the comments which talk about honoring the settlor's intent, effectuating the settlor's intent to the maximum extent possible. And that's what the Hoisington trust case gets into. In that case, the issue there was whether holographic markings on a trust could be deemed to be a separate instrument for terms of an amendment, and clearly they were not. But what the court did recognize there was that the settlor's intent is the gravamen of whether the trust was modified or revoked. And that court gets to the determination of when intent matters. And I think a reading of that case fairly represents that the intent of the settlor is both in play when he drafts the trust document, but also when he drafts his amendment. The meaning of the terms of the trust, you look to the intent of the settlor when he drafted the trust. The meaning of the amendment, how it is to be enforced, how it is to be honored, that's looked at in terms of the settlor's intent at the time he drafts the amendment. Now, as far as the Childs case goes that Mr. Caparella cited, it's way off both in terms of mileage as well as the facts. That case held that a settlor of an irrevocable trust couldn't later come in and modify the trust based on his later intent. Very different. An irrevocable trust, it is what it is once it's put into play, once it's signed by the settlor. In this case, it's a revocable trust that the settlor made sure to provide that it was amendable at some later time. So the Childs case, I don't even know that it hurts us But I don't think it really even plays into this court's decision much at all. At base, we have a settler who truly intended his trust to be modified. And I really don't see any argument from the appellants that that is the case. If that is the case, if Mr. Bone, a few months before he passed away, decided that he wanted to amend the trust, that decision, that intent, that solemn decision, as this court, to paraphrase this court in Hunter, should be honored, and it should not be overturned, if at all possible. The terms of the trust, as far as amendment goes, are non-exclusive. That means that under subsection C, where the terms of the trust do not provide a method which is exclusive, then any other method manifesting clear and convincing evidence of the settler's intent may be used to amend his trust. That's exactly what happened here. His intent was very clear. The record is replete with evidence of the conversations he had with Attorney Thomason, who, by the way, was his friend for 40 years, and his trusted attorney, and his business partner, and his attorney, in fact, and also a person who had nothing to gain or lose from doing this. There's been no sort of implication of undue influence or ill will. The only thing that we know is that Bob Bone intended to amend his trust, and he did the very best he could under the circumstances to do so. I'm happy to answer any questions the court may have.
Hearing none.
If that,
All right.
then
Thank you.
that concludes my argument. Thank you.
Mr. Barham. We'll now hear from the appellant, rebuttal, Mr. Caparella.
Thank you, Your Honor. The argument that under Tennessee Code, the Uniform Code 602C2B, which allows the settler to amend his trust by any other method manifesting clear and convincing evidence of the settler's intent, only applies to actions taken by the settler. There's a specific provision for when a trust is amended by power of attorney, and that is the only provision we're talking about here. So when they argue that we know from the intent of the settler what he intended when he did the amendment, that's completely irrelevant. That's his after the fact wishes about what he was doing here, and you can't consider his intent there because you have to just look at what the intent of the settler was when he reserved to himself personally the right to amend his trust. So you have to look at just the power of attorney section of the code. Now, how to interpret the term?
Let me ask you, he reserved to himself the power to amend the trust, but at the same time, he said the power to amend is personal to me and may not be exercised by any other person on my behalf during the time I am incompetent. That suggests to me that then it can be done by another person while he is competent, and it's undisputed that Mr. Bone was competent.
Your Honor, I submit that if you read the trust language, it only addresses the issue of incompetency. It says nothing about whether someone other than him can do it when he's competent. He reserves that personal to him because there's no mention of what we do when he's competent. So, and they admit, in their brief, they admitted that there is no express grant to a power of attorney when he's competent to amend his trust. So then they're left only with the power of attorney. And that brings out the comment to the Uniform Trust Code. It says,
another comment I want to ask you about, and it's 602E, where we're supposed to honor the settler's intent to the maximum extent possible. How does that play?
Well, you have to look at his intent at the time of the power of attorney and at the time of the trust, But you cannot, under the child's case and under this general principle that after the fact wishes of a settlor, even of himself, can't be considered, you don't look at his intent when he did the amendment because he didn't do the amendment. His power of attorney did. So you have to look at his intent at the time.
But the power of attorney handed it to him as the trustee.
But then you have to look at the language of the code, which says it must be expressly set forth in the power of attorney. And what was the term expressly mean? And this will be the first case to expressly determine what expressly means. And so therefore you look to the comment, which is this is a comment to section E, which is the power of attorney section of the trust code. An express provision is required because most settlers usually intend that the revocable trust and not the power of attorney to function as a settler's principal property management device. If you allow a pre-done power of attorney before the trust even existed, 8 years before the trust existed, to be amended by a power of attorney 2 years after the trust is done, not only amended but revoked. I mean, essentially, this power of attorney gave the power of attorney to do whatever he wanted to. You've created a co-settler. You've given enormous power to the power of attorney, and the comment to the Uniform Trust Code, I think, informs the definition of the word expressly, which means that power of attorney better mention this particular trust. Here, it doesn't even say any all future trust, but it better mention the trust that he's amending years later. Otherwise, you're going against the comment and giving extraordinary settler power to a non-settler, in this case, the power of attorney. That's why I think when Your Honor sits down to think about this, what you should think about is the consequences of interpreting expressly as broadly as they want to, which means as long as you have a trust 8 years before, 20 years before, as long as you have a power of attorney 8 years before, 20 years before that refers to a trust, that person can amend any trust in the future carte blanche, and that's not what should happen. So we ask that the court reverse the trial court and declare that the trust amendment was invalid.
All right. Thank you, Mr. Caparella, Ms. Franklin, and Mr. Barham for your arguments. They have given us a lot to think about. We'll take it under advisement. That concludes the morning docket.